Welcome to Class 3 of Understanding Patent Act 1970. Today we will learn first one is Patentability Criteria, second one is Section 3 of the Indian Patent Act 1970, that is Non-Patentable Inventions, and third one is Case Study on Non-Patentable Inventions. Let's start. Patentability Criteria. The criteria for patentability are essential for determining whether an invention qualifies for a patent. And the three primary criteria are: first one is novelty. What it means? The invention must be something completely new and not known to the public before, and it shouldn't have been shown or described anywhere before, like in books, products, or other patents. Why it is needed? If the invention is already out there, it can't be patented because it's not new. And how it is checked? They compare the invention to all known information, which is called prior art, and if they find something exactly like it, then it's not new. Second one is inventive step, that is non-obviousness. What it means? The invention should be more than just an obvious change or improvement to the existing things, and it should involve some creativity or cleverness that wouldn't be immediately obvious to the experts in the field. And why it is needed? If an expert could easily come up with the invention by combining what's already known, it's not inventive enough to deserve a patent. And how it is checked? They consider whether someone with ordinary knowledge in the field would have easily thought of the invention based on what was already known. Next, third one is industrial application. What it means? The invention must be useful in some industry, meaning it can be made, used, or applied practically, like in manufacturing, farming, or technology. Why it is needed? The invention should be something that can be used in real life and not just an idea or theory. How it is checked? They make sure the invention can actually be made or used in a practical way in some industry. And if it is just an idea without any practical use, it won't meet this requirement. Next is Section number 3 of the Indian Patent Act 1970, which lists things that cannot be patented. First one is Section number 3, subsection A. What it covers? The inventions that are frivolous, silly, or go against well-known natural laws. For example, a machine that claims it can run forever without any energy. This breaks the law of conservation of energy. Second one is Section number 3, subsection B. Under this, inventions that could be dangerous or harmful to the public, order, morality, or health cannot be patented. For example, a device for hacking into secure systems or a method for cloning humans. Third one is Section number 3, subsection C. The discoveries of scientific principles, abstract theories, or things that already exist in nature cannot be patented. For example, discovering a new plant species or coming up with a mathematical equation. Next is Section number 3, subsection D. Discovering a new form of known substance that doesn't make it work better, or finding a new use for a known substance that doesn't involve any significant change. Means there is no increase in the therapeutic efficacy of the known substance. Then this cannot be patented. For example, a known drug in a new form, like a tablet instead of capsule, that doesn't improve its effectiveness. That is therapeutic efficacy. Fifth one is Section number 3, subsection E. Substances made by simply mixing things together without creating any new properties. For example, mixing two painkillers together without any added benefit. Section number 3, subsection F. What it covers? Just arranging or rearranging known devices that work separately without adding anything new. For example, Attaching a torch to an umbrella handle where both work independently. Seventh one is section number 3, subsection H. Methods of farming or gardening. For example, a specific method for growing a certain crop cannot be patented. Next is section number 3, subsection I. Methods for treating humans or animals to cure diseases or improve health. For example, a new way to treat cancer or any other diseases in humans. Next is section number 3, subsection G. Plants and animals except for microorganisms and natural processes for growing plants and animals cannot be patented. For example, a new breed of a dog or a genetically modified plant. 10th one, section number 3, subsection K. Mathematical method, business methods, computer programs and algorithms cannot be patented. For example, a new accounting software or a financial model. Section number 3, subsection L. Creative works like literature, music or art, including movies and TV shows, cannot be patented. For example, a new movie script or painting. Next is section number 3, subsection M. Schemes, rules or methods for performing mental acts or playing games cannot be patented. For example, a new chess strategy. Then 13th one is section number 3, subsection N. Ways of presenting information. For example, a new way to organize data in a spreadsheet, or the information if it is presented in the form of audio, video, chart form. This is not patented. 14th one, section number 3, subsection O. The layout design of integrated circuits. For example, the design of microchip circuitry. Next is last one, section number 3, subsection P. Inventions that are based on traditional knowledge or just repeat what's already known. For example, a herbal remedy using ingredients like turmeric, neem and basil, which are already known for their medicinal properties, cannot be patented. Next one, case study on non-patentable invention. Novartis AG versus Union of India case. The Novartis AG versus Union of India case is a landmark decision in Indian patent law, and the Supreme Court of India made this decision in 2013. The case was about whether Novartis could get a patent in India for a cancer drug called imatinib mesilate, which they sell under the brand name Glivec, and the ruling had significant implications for patent laws and access to affordable medicines in India. What happened in this case? So, Novartis, a big pharmaceutical company, wanted a patent, a new version of a cancer drug called imatinib mesilate, which they sell under the name Glivec. And the Indian Patent Office said no to the patent because they didn't think the new version of the drug was different or better enough to deserve a patent. So, Novartis didn't agree with this decision, and so they took the case to court, arguing that the Indian law was too strict and went against international rules. What was the key legal question? The main question was whether the new form of the drug whether the new form of the drug was really a new invention under Indian law, and if it was better enough to be patented. What the court decided. The Supreme Court of India ruled against Novartis and they said the new form of the drug wasn't innovative enough to be considered a new invention and it didn't show a big enough improvement in how well it worked compared to the existing drug. Why it's important? Impact of this case. First one is no evergreening. The decision was a big deal because it stopped the practice of evergreening, where companies make tiny changes to a drug just to extend their patent and keep others from making cheaper versions. And second one is affordable medicines. And this ruling meant that other companies in India could make and sell generic versions of the drug, which helped keep medicines prices lower and more affordable for patients.